Well, hello everyone, I welcome you all at Smarty Education. Today we have to start with Indian Contract Act. This will be the most interesting chapter that you will ever read in your CSEET exam. But before starting the lecture, I have one and last request for all of you to please watch the lecture till the end. This will be lecture number 1. I hope so you have full concentration in the lecture. So let's begin with the lecture. So there was a Mr. A who wanted to start an airline business. Obviously, he will need airplanes to run the airline business. Okay. So he called an agent from an airplane company which supplies airplane who run the airline business. Okay, they discuss every detail in the cafe shop, and in the discussion agent said, please come tomorrow to my office for further clarification related to your purchase to our airplanes. So next day they communicated everything related to supply of planes, and finally A and that agent agreed at a price of 1 crore for supply of 100 planes. So finally what happened that A said that okay, I will purchase airplanes for 1 crore and you will supply me 100 airplanes, and on behalf of company the agent said, yes sir, okay, we will supply you 100 planes at the price of rupees 1 crore. So from here they made a contract containing all the details. So there was a contract between A and that company in which A will get airplanes, in exchange company will get 1 crore rupees for the payment as an airplanes. Okay. So next day, after a week, all the planes were supplied to A and the contract was successfully executed by that agent's company. It is also known as executed contract. So what do you mean by this conversation? What do you mean by this example? So in this example, we got to understand that there should be 2 or more parties in the contract, and in this contract there were some legal obligation and duties were also created between these two parties. Okay, so now let's see lessons to be learned from this example. The first one is contract should be made between 2 or more parties. Is an agreement creating obligation and rights? How does it create obligation and rights? So first of all, A's right is to get 100 airplanes from that company, and company has a right to get 1 crore for the supply of airplanes. Now let's take obligation. Obligation refers to responsibility. A's responsibility is to pay 1 crore and the airline companies to supply, responsibilities to supply 100 airplanes to A. Okay, the third point is an offer and acceptance is necessary. Like in case of A and that company should have accepted that offer. So first of all, A gave an offer to the company and company finally accepted. So there must be offer and acceptance. So there must be consideration. So what do you mean by consideration? Consideration basically means what I will give you, what you will give me in exchange. So in this case, like A offered 1 crore and the company supplied 100 planes in exchange of it. Contract must be legally enforceable. So what do you mean by this sentence? This sentence basically means that whatever contract you do, you should do it under as a public policy and should be enforceable under the code. Any contract which is not enforceable under law will not be able to approach the court. Means court will not do anything related to that contract. So now let's talk about most important conclusion from our example. So in this example, the most important conclusion is that offer plus acceptance is equals to promise, and promise plus consideration is equal to agreement, and agreement plus legal responsibility is equal to contract. Let's understand these 3 lines in a very simple manner. First of all, he gave the offer. Okay, he get the risk. The company accepted it, and offer and the sum of acceptance will come into the promise. Okay, whenever offer is added to that acceptance, when one person signifies to do something, means to purchase something, and the company accepted, whenever there is a combination offer and acceptance, it will always be called promise. So the next thing, that promise and sum of consideration will term into the agreement, and agreement plus legal enforceability will come into the contract. So what happened in our example? A gave the offer to the company for the purchase of planes. Company accepted it, then it converted into promise, then through the consideration of giving 1 crore by A to the company, and company in return gave planes to A. It will be called consideration, and consideration plus promise came to known as agreement, and when agreement is enforceable by law, it is known as contract. So if you have come here, please write present sir in the comment section so I can mark your attendance. In the description box of the video you can find notes link. Okay, so now let's talk about important points related to Indian Contract Act 1872. So first of all, remember that Indian Contract Act 1872 came into force on 1st September 1872. The second point is the preamble to the act says that to define and amend certain parts of law relating to contract. So whatever parts will be amended, it will come under Indian Contract Act 1872. Okay. It doesn't deal with all kinds of contract. Why? Because it deals with certain kind of contracts. So let's see, like partnership, sale of goods, negotiable instrument, insurance, etc. are dealt by with their separate acts. It only deals with some specific case laws. Okay, specific contracts. It was codified in a special manner. How was it codified in a specified manner? Because since you know that Indian Contract Act 1872 means it was initially from the British era, therefore it is called and codified in very special manner. Okay, so the Indian Contract Act is further divided into two parts. The first part will deal with generalized principle, means some general cases which cover section from 1 to 75. Remember, very important for your MCQ. Second part deals with special kind of contract like contract of indemnity, guarantee, and section will cover from 124 to 238. So first part will cover generalized situations, means already judgments are given and we can refer to that. And second part means some special cases related to contracts which differ from party to party and case to case. Now let's talk about offer or proposal. So first of all, you must have heard the proposal word in the marriage and offer word in the business. So section 2A of the Indian Contract Act defines proposal or offer as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that person to act or abstinence, he is had to make a proposal. So whenever someone said to you, I will do it for you, but you have to do it for me, it will be called as proposal, willing to do or not willing to do something. So when I will take the example, you will clearly understand this. For example, A offers his car to sell to B. Okay, so it will be called A's willingness to sell his car to B. Okay, A's willingness to do so by selling his car to B. So it will be called as to do. And abstain from doing something, let's see, abstain from doing something can mean that A can offer not to sell his car to anyone except Mrs. B. So what happens here is that when A is willing to do something to sell his car to Mrs. B, it will be called as to do. And when Mrs. B wants to buy the car but she doesn't has money, so she can put a proposal that, or A can put a proposal that I will not sell my car to anyone if you pay me a amount as a booking, so I will not sell it to anyone. Okay, I will not sell it to anyone. I hope you got the point. To do means when we are willing to do something. Abstain from doing something means when we do not want to do anything as per our contract. Okay, I hope you got the point. Now let's talk about rules governing offer. Okay, first of all, offer must be clear, definite, complete and final. It must not be vague. Okay, for example, a promise to pay an increased price for horse if proves lucky. So in this case, it's too vague. Why it is too vague? Because the offer is not definite, because it is depending on a certain condition. For example, A will promise B to pay the price of the horse if the horse proves to be lucky in any case. So this doesn't make any sense. Okay. So the next one is an offer becomes effective only when it has been communicated to the offeree so as to give him the opportunity to accept or reject the same. For example, when A is purchasing the horse, B should give him all the relevant information related to whether the horse racing is good, whether the horse behavior is good, related and any other information. The third one is offer may be made by express words, oral or written, or it may be implied by the conduct. So what does it mean by offer can be expressed by orally, by writing on a paper, or implied conduct. So what do you mean by implied? Implied conduct means you cannot claim the offer reward until and unless you find it. Until and unless, for example, finding a missing dog. The communication for an offer may be specific or general. The communication for an offer may be specific or general. Means specific offer means given to a certain individual to accept, or general offer means for the general public and anyone can accept that offer. Now let's talk about lapse of an offer. So lapse basically means brokerage of an offer, means when the offer will not be available. Section 6 deals with various modes of lapse of an offer. It states that an offer lapses when the offer will be breached. So let's see the points. It is not accepted within the time period. If you do not accept the offer within the time period, the offer will lapse. The second one is it is not accepted in the prescribed mode. For example, by sending a letter by mail when early reply was requested. For example, there was an auction and you were offered to purchase something, but you didn't apply it early, so you will not be able to accept that offer. The offeree rejects it by distinct refusal to accept it. Means the offeree has rejected the offer, so the lapse of an offer has happened. Okay, either the offerer or the offeree dies before the acceptance. Anyone who dies, then the offer will be end. Okay, the acceptor fails to fulfill a condition precedent to an acceptance. For example, car sale was offered to B, and B cannot fulfill the condition of paying the down payment of 1 lakh to A for booking the car. Then the next one is the offeree makes a counter offer. So what do you mean by counter offer? For example, I give you an offer to sell my bike for 10,000 and you say that I will purchase only at 9,000. So it will be depend on me whether to accept it or not, but it will be called as counter offer and it's amount to rejection of my offer. Okay. Now let's talk about revocation of an offer. Revocation of offer basically means revocation by the offerer. Revocation basically means that you are revocating the offer or you are ending the offer. Okay. An offer may be revoked by the offerer at any time before acceptance. Revocation must be communicated to the offeree as it doesn't take effect until it is actually communicated to the offeree. So for example, there was Mr. A and there was Mr. B. A wanted to sell his car to B, but something happened in the selling of car. A said that I don't want to sell it because you have not accepted it. I am communicating to you that my car is no longer available for sales. Then the third one is an offer to keep open for a specified time is not binding unless it is supported by consideration. If this person pays a booking amount as 10,000 to A for accepting purchase of bike, then it will be open for a specific time and it will be closed until and unless B has paid that amount. Okay. Now let's move on. Acceptance. Now let's talk about the concept of acceptance. Under section 2b, acceptance has been defined of the contractor. When a person to whom the proposal is made signifies his accent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. So whenever an offer has come to you and if you accept it, it will convert it into promise. Okay. Now let's talk about rule governing acceptance. Okay, so the expected acceptance can be same expressed by spoken, written or implied by the conduct of parties that I already explained in the previous slides. Then the second one is if particular method of acceptance is prescribed, the offer must be accepted in the prescribed manner. Okay, same principles are applying here of that offer. Acceptance must be unqualified and absolute. It means that counter offer should not be there. Then the fourth one is a counter offer operates as a rejection. That's what I told you. The third and the fourth point are already same. Okay, fifth point is acceptance must be communicated to the offerer. For example, there was Mr. A. A gave offer to B. And B communicated that I am accepting your offer. Then it will be called as complete communication between the offerer and offeree. Okay, so till now I didn't tell you the meaning of offerer and offeree. So offerer means that the person who is giving the offer And offeree means who will accept the offer. This is considered as offeree in case of A and B, and A will be considered as offerer. So mere silence on the part of offeree doesn't amount to acceptance. It means that if you are silent and you have accepted in your heart that I have accepted this offer, so it will not be considered as acceptance. Then the next one is, if the offer to be acted upon, then the acceptance is not necessary unless it requires to be communicated. For example, finding a missing dog. Before finding it, you must communicate with the owner regards that you are going to find the dog. Acceptance must be given in a specific time. For example, a specific time period can be allotted for you to accept the offer. Okay. Now let's talk about the term promise. So what do you mean by promise? Promise basically means to do something. So according to section B, remember sections are very important in this chapter. Section B of the Indian Contract Act, when the person to whom the proposal is made signifies his accent, therefore the proposal is said to be accepted. A proposal when accepted becomes a promise. So whenever we give an offer to someone, the offerer gives an offer to the offeree and the offeree accepts it, then it will be called as a promise under section 2B. Now let's talk about an agreement. Agreement is defined under section 2E of the Indian Contract Act. Every promise and every set of promise forming the consideration for each other is known as agreement. So set of promise and every set of promise is known as agreement when the consideration is involved. The consideration meaning means I will give you something, you will give me something, both parties will be happy for that. Okay. So agreement will include two things. Like features of agreement are plurality, there must be two or more person. Consent ad idem means there must be meeting of mind, and free consent. The term free consent, remember, very important term in your MCQ pointer. Free consent basically means matching of mind and permissions. Okay. Now let's move on. Let's talk about consideration. So section 2D of the Indian Contract Act 1872 defines consideration when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something, such act or abstain promise is called consideration. Consideration basically means that in return, what does mean by consideration? Basically means that if I give you something, you will have to give me something and I will give you something, means exchange. For example, there was Mr. A and Mr. B. So A said that I will sell you my bike. In exchange, B said that I will pay you 5,000. So there is a consideration. Okay, A will receive 5,000 and B will receive bike. So in exchange, it is called as, in simple language, consideration. Okay, at the desire of the promisor, the promisee or any person has done. Okay. Important points related to consideration. Consideration at the desire of the promisor. Consideration at the desire of the promisor. Section 2D of the Act begins with the statement that consideration must move at the desire or request of the promisor. It means at the wish of the promisor. For example, if A rushes to B's house when his house was at fire, it is voluntary act but not a consideration. Similarly, if B requests A to help, then it will be a good consideration. So consideration at the desire of the promisor. For example, in this case, what happened, that there was a fire in A's house. Okay, this is A and this is B. So B voluntarily went to A's house to water the fire, and so B is not asking for any consideration, but specifically when A calls B at the request of, so B's house is on fire and A went to help him. Okay, A went to help him, and what happened, that A will not get any consideration, but at the request of B, if A comes to help, then it will be called as good consideration. When at the desire of promisor you can do something, it will be called as consideration at the desire of the promisor. If you didn't get the point, please comment down in the comment down section. Okay, comment down below section. Okay, comment down below. Okay, so now let's talk about consideration may move from the promisee or any other person. In English law, consideration must move from the promisee, so that a stranger to the consideration cannot sue on the contract, but if the stranger want to enforce, he can enforce. So it basically means that consideration may move from person to person. So it basically means that your father pays your coaching fees, so it will be called as consideration is moving from person to person. But if that stranger wants to wants to enforce you in the court, it will be called as consideration moved from the promisee or any other person. Okay, so when I will take the example, you will already get to understand that. So let's take the example. Under Chinnaya versus Ramaya case, what happened that an old lady by deed said to her daughter that I will leave all my property after I die to you if you pay annuity to my brother, and the daughter agreed that So basically, first of all, let's get to understand the annuity. Annuity means paying certain amount at the end of every year, paying certain amount to my brother will be your responsibility after I die. So you will have to pay a certain amount to my brother as an annuity. Okay, so therefore the lady gave her all property to her daughter, and the daughter agreed, and when mother died she paid annuity for some years, then stopped the payment, and then the brother went to court because she was not paying the amount to the brother of that lady. Okay, so till now we have here. Okay, so now what happened that then the brother went to court. Okay, the daughter said that no consideration has been received to her, so why she will pay then, because the brother is a stranger to the party, okay, stranger to the contract. So why she will pay? The judges said that your mother has already gave her property to you as a consideration on behalf of your brother, so you will have to pay annuity to that to your mother's brother. Okay, so in this case we get to understand that consideration can be paid on behalf of a person. So in this case the lady paid consideration on behalf of brother. Okay, so last topic, what is a contract? So till now we get to understand that offer plus acceptance is equal to promise, and promise plus consideration is equal to agreement. An agreement, when enforced with law, it is called contract. So let's see the contract definition. The contract is defined in section 2H as an agreement enforceable by law. An agreement therefore is a combination of two elements, agreement and obligation. Obligation means to do something in the contract and agreed between the parties. Okay, so that's it for today's guys. I hope you liked the video. So thanks for watching. For current affairs daily PDF, you can join my Smarty Education WhatsApp group. For joining our group, you have to send message on this WhatsApp number, and if any doubt, comment down below or send doubts at this number of WhatsApp. So that's it for today's guys.